My name is Carmen Stewart, and I'm the Acting Information and Privacy Commissioner for Nova Scotia. On behalf of my office, the Office of the Information and Privacy Commissioner, and our co-sponsors, the Centre for Law and Democracy, the University of King's College, the Right to Know Coalition, and the Canadian Taxpayers Federation, I want to thank you all for coming out tonight for this very important conversation about Nova Scotia's fundamental access and privacy rights. I'd like to remind everybody that we are recording today's panel. The cameras are right here and they're pointed at the stage only, so you won't be recorded on them, but if you stand up and ask a question later, your voice may be recorded. It's our intention to post it to the YouTube so that people who couldn't be here today might get a chance to see it. So as you may know, this is Right to Know Week in Canada, with the 28th being the actual Right to Know Day. Every year, about 40 countries and 60 non-governmental organizations around the world celebrate Right to Know Week, and it serves as a way to raise awareness for individuals and their right to access information, and promoting information as access to information is an essential right to both democracy and good governance. And this year actually marks our 25th anniversary for our office as well, so we've taken this as a perfect opportunity to bring this excellent panel together to discuss what the future of access and privacy rights for Nova Scotians may look like and share their ideas on how it might be improved. So I'm pleased to announce the moderator, Professor Wayne McKay of the Sherlock School of Law from Dalhousie University. Professor McKay is a nationally recognized teacher and scholar and accomplished author in the areas of constitutional law, the Charters of Rights, human rights, privacy law, and education law. In 2006, he was invested as a member of the Order of Canada by the then Governor in recognition for his commitment to passion for human rights, equality, and diversity in Canadian society. In 2013, he was voted one of Canadian Lawyer magazine's top 25 most influential lawyers in government, non-government, association category, and has been presented with a number of excellence in teaching awards. With that, I turn it over to Professor.
Thank you very much, and welcome to our session tonight, which is Democracy in Action, the Future of Your Right to Know. I mentioned for some of you who might have struggled finding the location, it is all about accessibility, but it's information we're looking for. It's not necessarily the room itself, or you might have been looking for both. Anyway, we're lucky to have an excellent panel here to address this important question tonight, and I'll be introducing them and getting to that in a moment. But first I thought I'd just say a little bit about kind of the ground rules and how we plan to proceed tonight. And first of all, we want it to be fairly informal, as we're all sitting down and you're sitting down, first of all. And with that in mind, a couple of sort of functional things. There is a washroom if you go out to the right here and follow the signs to the washroom, which are relatively clear. Getting back is a little trickier, but anyway, I think you can get there. Whether you get back may be more of a challenge. And there's also tea, coffee, and some refreshments, cookies, and so on out around the corner. And people should feel free to get up and have a cup of coffee or something and come back to your seat. So we're, again, fairly informal about it. We thought it important, given that we've got a pretty fair chunk of time to work with here, to try to break it up a bit. So the process is going to be that I will introduce and ask a question, and then have the various panelists deal with that question for a set amount of time, and we'll go through that process till the end of the questions, which I think are 6, not massive, I think it's 6 or 7, and then have time at the end for audience questions and interaction. So that's the plan of action for the night, and I'll do my best to try to ensure that we do have some time for interaction at the end. If you do have a burning question, perhaps mark it down, or however you mentally record it, and perhaps save it for that time period if you can. So first of all, I'll just by name introduce the other people here at the table, although I'm going to save the more detailed introduction to the first question that I ask. On the far left, Graeme Steele, who many of you will recognize, professor at the business law at Dalhousie, based at the moment. Next to him, Michael Karanakolis, who is the president of the Right to Know Coalition of Nova Scotia. And on his, well, I'm taking right, your left, I guess, Jennifer Gerrans, who's the senior investigator at the Information and Privacy Commissioner's Office. And to my immediate left here, Laura Notas, who is legal officer for the Center for Law and Democracy. As I say, I'll give them more proper introductions in a moment. So with that in mind, I will introduce Graham first, and then put it over to him for the first question, which I will read at that point. So let me start with introducing Graham. Graham Steele, professor of business law at Dalhousie, as I indicated. His self-written bio here, I think, says he has trouble keeping a job. So I guess if he says so, it must be true. It does lead to him having looked at the issue of information and privacy from just about every angle possible. When the current law in Nova Scotia came into force in 1994, Graham was working as in-house counsel for the Workers' Compensation Board and was named as part of that job as the person, the administrator, to deal with FOIPA, Freedom of Information and Protection of Privacy Act, which we'll be probably using for those who might be new to this FOIPA a fair bit. He was the one in charge of dealing with that at that time. After leaving the Workers' Compensation Board, he became a frequent FOIPA applicant as research director for the provincial New Democratic Party. So we used it as an applicant in that sense. He was opposition MLA from 2001 to 2009, and during that time was the lawyer on 4 FOIPA court applications brought by the NDP caucus, including a leading case, O'Connor versus Nova Scotia. So, and then the courts dealt with it. And finally, Graham was in cabinet almost 4 years, in 2009 to 2013, first in finance and then economic development, and there was responsible for responding to those kind of applications. So he has covered just about every angle of this. And his final note is that he's currently professor of business law, but that he's losing his job on Tuesday. So I'll leave it to him to explain whether that's a good, bad, or indifferent thing. So I will ask the first question, and then send it along to Graham. And the first question is, over the last 25 years, each of you on the panel have had a variety of different roles in the public, advocacy, or private sectors, both on the access side and in different areas. Tell us a little about your experience with FOIPA and why Nova Scotians should be concerned about the right to know. And I'll be asking each of the panelists that same question. Over to you, Greg.
Okay, thanks very much, Wayne. We're just starting with the microphones. I want to make sure that everybody can hear me if it's like this distance. Okay, great. So Wayne has sort of read out a brief biography, and it is kind of amazing that with my inability to keep a job, I just keep bouncing from a different part of the Freedom of Information system to another. In fact, the job that I have now as a business law teacher at Dalhousie is the one job I've had that does not involve freedom of information at all. But it wasn't very long after I left law school that I went to the Workers' Compensation Board when the current act came into force. I'm that old that I was there. And so I was, my boss said, oh, this looks legal, why don't you do that? So I became the administrator for the Workers' Compensation Board of the Freedom of Information Act when it came into force in 1994. And I was part of the meetings in government, the first meetings where all these administrators would say, what are we going to do with this? How are we going to deal with this? And it was all under the leadership of a gentleman, a very fine gentleman by the name of Bob Doherty. How many of you here know Bob Doherty? Bob was at the Department of Justice. He was given the job of leading the implementation of the act. So I was there, did that for a few years, and then, as Wayne said, then I became a frequent applicant. I filed dozens of Freedom of Information applications. I had a staff in the caucus office who I was supervising them, so we filed dozens and dozens of applications, big things, little things. Just to date myself again, one of the biggest applications we ever made was for all the government information on Y2K. Right? And if you know what that is, I know how old you are. And that was interesting, and I learned a lot about about how to work with administrators, how to negotiate with administrators, how to work with the commissioner's office, which at the time was really small, and just make things work by negotiating. So that was a really good experience as well. But because I was a lawyer, I also had the opportunity to go to court, and that's the one I want to focus on, because when you look at all the roles that I've had over the years, the one that I think has had the most lasting impact was as the lawyer on behalf of the applicant in the O'Connor case, which has become the leading case where the Court of Appeal, Nova Scotia's highest court, laid down the fundamental principles about how our freedom of information law should be interpreted. We actually had lost that case, although we claimed to have won. But we didn't get what we wanted, except that the Court of Appeal laid down these broad principles of interpretation. So although we didn't get what we were looking for, it was in retrospect a big victory, because it said, this law really means something, and of course now that case has been cited in every other significant freedom of information decision since then. So that's probably the thing, looking back, that I'm most proud of. But even though I've been involved with this system for 25 years, ever since it started, the fundamental reality has never changed, which is we all need to care about the right to know, because when you're in government, you are doing it the only authority you have is to do things on behalf of the people. It's the people who've given you the authority to act on their behalf, and they have a right to know what you're doing and why you're doing it. And no matter what role I've been in, even as a cabinet minister, that fundamental truth has never changed. So I've had this great and glorious opportunity to see the system from many different angles. Just about the only one I've never had is working in the commissioner's office. But that's sort of my background. That's why we all need to care. It does make a huge difference, but our laws got bogged down, and I think we'll talk a little bit about that, Wayne, as the session moves along.
Not to plant any ideas here, but of course there is an opening in the what I believe, but we'll leave that. Again, the question, and I'll give Michael a better introduction or fuller introduction, is basically your encounters with FOIPOP and why we should care about it. So Michael Karanakolis is the president of the Right to Know Coalition in Halifax, an NGO which is based in Halifax, promotes government transparency, also currently employed at Yale Law School, where he leads the initiative on intermediaries and information at the as the Wikimedia Fellow, and I'll let him elaborate on that. Michael has a Bachelor of Honors, a BA Honors from Queen's University, and an LLB from the Schulich School of Law at Dalhousie, an LLM from the University of Toronto Law School, one of those other law schools. He has published widely in a number of areas related to information and freedom of expression, and has a recent article that deals with information and digital rights, and it's entitled "Subverting Democracy to Save Democracy, Canada's Extra-Constitutional Approaches to Battling Fake News," and it's coming out in the next issue of the Canadian Journal of Law and Technology. So, Michael, over to you.
Thanks. And thanks very much for that introduction, and thanks to the OIPC for this invitation. I was quite excited to have the ability to participate in this event. I do not have 25 years of experience on this issue. I would have been a very precocious 12-year-old if I was working on the access to information issues, but I do have around 10 years of experience, mostly coming at it from the civil society and advocacy side. Obviously, I've been a requester myself. Starting out with the Right to Know Coalition, or prior to what I've been doing now with the Right to Know Coalition, which is a Halifax-based NGO that works to promote transparency, mainly in Nova Scotia and in Halifax, but to a certain degree outside of that as well as with my other role, which I was just hired on as the Wikimedia Fellow at Yale Law School, where my work is more broadly around information flows. So you just mentioned the recent piece I have on fake news and disinformation. So I am working broadly on issues related to freedom of expression, but that includes work related to access to information, right to information. In both my role with the Right to Know Coalition, as well as my time as the Wikimedia Fellow, there's been a decent opportunity to interface with the public in terms of folks that are filing access to information requests. You know, the Right to Know Coalition received and continues to receive a steady stream of emails and calls from people who are, you know, struggling to navigate their way through the FOIPOP system. And, you know, there's also a component to that at Yale in terms of the Media Freedom of Information and Access Clinic, which also works with journalists in that area to try to file, to try to navigate the American versions of the system. And in both cases, I've learned a lot about the importance of the right to information and why these cases, why the ability to actually go to the government and specifically ask them for documentation, for underlying information about an issue that you're looking at is so critically important. Most of my interaction with that has been working with journalists and civil society, and it's been incredibly eye-opening. I have seen firsthand, I've spoken to journalists in Indonesia that are filing right to information requests to investigate, you know, disappearances of their colleagues at the hands of the military. I've spoken to journalists and civil society folks in Myanmar that are pushing for right to information legislation for a democratic guarantee to safeguard their new democracy and to make sure that they have some ability to actually get reliable information out of the government, which is something that they've never had before. You know, I've worked with environmental NGOs in Malawi who are using new right to information legislation that's been passed there in order to finally get accurate, you know, statistics about pollution that's being dumped in lakes and waterways. There's tons and tons of examples everywhere of journalists, human rights defenders that rely on this as a critical way to do their job. But in order to bring it kind of closer to home, or to tell a story that people might be more familiar with, I think that what we've been seeing south of the border, what we've been seeing in the US under the current administration there, also paints a very vivid picture of why access to information as a specific and fundamental right to get underlying documentation is so important, and why the increasing dissemination of open data or publications by the government is not a replacement for that. And that story is that, you know, time and time again over the last 6 months, we've seen the American administration, the Trump administration, putting out their own description of what they're doing, their own description of what's been going on, and only to find out a week, a month, a couple of months later, that the description that we've gotten from the government has absolutely no connection to the underlying documentation and what it actually says. The Mueller report is the most glaring example of that, where you have the government saying, basically putting out a press release and saying, here's the information that we have. And then only much later, when the actual information comes out, do you realize that it's been spun very heavily. And without accusing our governments here of going to that level of perfidy, that kind of spinning is very common, and it's very natural for governments to do. You take the information and you present it in the most favorable possible way. And the importance of access to information is it allows journalists, human rights defenders, citizens to actually peek under the hood and say, okay, well, you're telling me this is what's going on. You're telling me this is what we're seeing and what we're hearing and what the operations are. But I'd like to know what your documentation is based on and the actual underlying information. And that kind of fundamental right is such a critical tool for journalists for exactly that reason, because it allows you to cut through the spin and cut through the PR and find the actual story. Journalists, civil society, it's such a critical tool for their work. And you know, that was another interesting aspect of this, and that's one of the reasons why, as someone who's been involved in advocacy on this issue, it's never difficult to get the media interested when you're talking about access to information, freedom of information issues. It can be difficult to get the public interested, but journalists always have an intuitive understanding of why it's important, because every journalist worth their salt has a dozen stories of their own frustrations with these systems, because they realize it's a critical tool, and they also realize the extent to which governments can try to subvert or frustrate these systems, which is another indicator of why they're so important, because it allows the public and the media to find to get an unvarnished view of the truth. So I guess I'll hold off there, but we'll be discussing that in more detail later on.
Thank you very much. Next up on this same question, Janet Burke-Gerrans, who's the Senior Investigator and newly appointed Acting Director of Investigation and Mediation at the Office of Information and Privacy Commissioner in Nova Scotia. She brings 15 years of multi-sector public administration experience to this job, and also her background in sociology and law. And as a former research student and student of mine, which we won't hold against her, her past roles include academic writing in the areas of education, equality, and freedom of expression, and consulting in public education, labor relations, collective bargaining, post-secondary administration, and the management of public housing services. She has been with the Information and Privacy Commissioner for the past 2.5 years, and is currently, as I've indicated, the Acting Director of Investigation. She's responsible for leading the team of investigators who engage in the independent review of public body decisions on the front lines. So, over to you, Jen.
Thank you very much. So I'm going to focus a little bit on my experience over a decade working in public bodies. So during my time, I saw firsthand employees taking the possibility of FOIPOP requests very seriously, carefully documenting their interactions with challenging clients sometimes, with that in mind. Really being very careful about how to document it, just the facts, no embellishing, no inflammatory language, just in case there was a FOIPOP request. I saw firsthand employees' experience where an offhand comment in an email was disclosed and that caused some embarrassment. I saw firsthand individual clients who were empowered because they were able to use the results of an access to information request to advocate for themselves with the public body. So on the whole, I think it's a very good thing. I think freedom of information moves public bodies toward more professional ways of documenting and talking about their clients, because there is the possibility that this will become public. There is the possibility that people will see what has been written, and that is taken very seriously. It influences how clients are talked about behind the scenes, how the public is talked about behind the scenes, and how it's written. It also levels the imbalance of power between individuals and the public and public bodies. But I also saw firsthand tactics used to avoid documenting or communicating in a way that would escape capture by access to information requests. I was advised on how to do that when I started a new role at a public body. Our current premier has made some worrying comments to that effect. So, I think at the end of the day, there's no question that public exercising their right to know and to access information has a big impact on how public bodies conduct their business, how they engage with each other, and how they do their day-to-day work. But I do think that citizens should be concerned. As much as we have loads of conscientious public employees who are serving us and working for the benefit of the public, we also have individuals and attitudes that are willing to push boundaries, that are willing to skirt rules for other purposes, and unfortunately our current laws simply are not strong enough to deal with them. And we're going to talk about that a little bit more later, but that's kind of the experience that I bring, the firsthand what I saw, the good, bad, and the ugly of it. But there's a lot out there happening, and we certainly know that there's an impact from the exercise of these rights. And I think I'll leave it at that for now.
Thank you. And last but not least, Laura Notas, who is the legal officer at the Center for Law and Democracy, which I suggest she might just explain briefly when she does speak, with a background in international human rights law. She earned a JD from Georgetown University Law Center in Washington, D.C., 2015. After graduating, she worked in land rights for rural communities and indigenous peoples at the World Resources Center. She also has conducted legal research and policy work around issues such as political prisoners, refugee policy, and the prevention and prohibition of torture, and protection for human rights defenders. During law school, she completed internships with several nonprofits, and at a DC-based human rights law firm, she also holds a bachelor's degree in international political economy from Fordham University in the Bronx, and a certificate in refugee and humanitarian emergencies from Georgetown. So, Laura, over to you.
Yes, so as you may have gathered from that biography, I'm a newcomer to Nova Scotia, which means I actually know very little about your Nova Scotian right to information law. I can much more bring in an international or comparative perspective. Yes, so I work at the Centre for Law and Democracy. We're based here in Halifax. We're a small, fairly small nonprofit. And we actually mostly work globally. You know, obviously, if there's an opportunity to work on right to information here in Canada or specifically in Nova Scotia, we do. But a lot of our work is overseas, working with governments in every part of the world on right to information issues. You know, including countries that are just putting in place right to information laws, ones that are transitioning from more authoritarian regimes and trying to figure out how to be more open. You know, and so I've seen kind of the whole range of qualities of right to information law, we'll say. One thing that my organization does that some of you may find interesting is we support the right to information rating, which ranks right to information laws around the world. So I think you can Google it, it's rtirating.org maybe. And it unfortunately does not have right now the provincial level laws in Canada, but it does have all the national laws, and it compares the laws globally. And one kind of interesting thing you'll see if you look at our rating is that the countries that are highest on the list are not countries like Canada, not countries in the developed world that you would expect to be higher. And one reason for that is a lot of these countries enacted their laws a long time ago and haven't gotten around to updating them, whereas some of countries that you might not expect to be on the list, like Afghanistan is currently at the top of our list. It has a very recent right to information law that is actually quite high quality. You know, of course, implementation is going to be a challenge for them, but you know, it always helps to have a good law to start with. So that's the background of my organization. I think I'll mention, just in terms of the importance of the right to information, to add on what everyone else has already said. One thing that I have found odd is that people don't always think of the right to information or access to information as a fundamental human rights issue. My background is very much in human rights law, and you know, when I say, oh, I work on freedom of expression or torture or arbitrary detention, people kind of get that, like, oh, okay, I know what that is. But if I say I work on freedom of information, I get some blank stares, and I think that's too bad, because it really is fundamental to the realization of so many other human rights. It's a part of the right to freedom of expression and the freedom of information to flow in society. Citizens have a right to know what their governments are doing, to know if they are acting in a way that benefits the public, and this means being able to access information held by the government. So I think that's just one additional point to make. In addition, you know, we've already heard how important of a tool right to information is, you know, for journalists and for lawyers and for people trying to hold their governments to account. But it's also just a fundamental human rights obligation for governments to be transparent about the information that they hold on behalf of the public.
Thank you very much to all the panelists. I think we're off to a great start, and certainly get an indication of the diverse and expert knowledge that is being brought to this issue tonight. So I think we're in for a good night. The next process that I'm going to engage in is to assign particular questions for somebody to take the lead response to, and ideally sort of within the 3-minute range, and then any of the other panelists can feel free to add a brief comment to that. So that's the next format we're moving to. And the question is, our Nova Scotia's freedom of information laws haven't changed that much over the last 25 years, but so much has changed in the world around us. What is the biggest change that has impacted how freedom of information laws function or don't function? in Nova Scotia, things like social media. Michael, I think this one, you get the lucky draw on this.
Thank you. Yeah, so I chuckled a little bit when I saw the poster for this evening's event, because there is one word on this poster which I think perfectly encapsulates Nova Scotia's record on this issue, and that is inaction. As you know, it was mentioned in the question, there hasn't been a lot of change, almost no major changes in our legislation over the past 25 years. And 25 years is an incredibly long time, especially when you talk about information, where the pace of change has been enormous. 25 years ago was the dawn of the commercial internet. 25 years ago was when the digitization was only just beginning, and there's been leaps and bounds made, not only broadly in terms of information management, in terms of our relationship to information, but in terms of the right to information itself over the past 25 years. I think 25 years ago there was probably less than 20 countries in the world that had right to information legislation on the books, and now there's more than 120. So this right itself has evolved dramatically around the world, and Nova Scotia is this little time capsule of like, oh, I wonder how information laws worked in the 1990s. Like, great, I can check that out. And that being said, that inaction and that stasis does not mean that the law is as good today as it was 25 years ago. That inaction should properly be equated with stagnation and ultimately with a growing weakening of the law, because there's been growing demand, there's been evolving expectations towards information, there's been growing digitization of information, which leads to a ballooning amount of records that are out there, and yet the same system remains in place. And it's particularly frustrating insofar as there's not a lot of uncertainty among civil society, academics, journalists. Everybody knows what needs to be done. You're going to hear a lot of those answers here tonight. The changes that need to be made are not a secret. They've been known at least as long as I've been active on this issue, and probably before that. But every year, it's almost like Groundhog Day. We come here and we talk about what needs to be done, and the political will has just never been there. So from that perspective, taking this kind of a longer and retrospective look it's important to think about it that way, and it's important to take this kind of a longer view. But fundamentally, it's also frustrating insofar as there are clear answers that are out there. This is not one of those difficult to solve, difficult to understand problems where everybody's got a different idea of how it should be done, and there's a lot of disagreement about what's going to work and what's not going to work. The answers to how to fix the Freedom of Information Protection and Privacy System are there, and they're very clear. And they're clear not just from looking at talking to international experts on this issue, but looking at other jurisdictions that have structured their laws in a better way, that have implemented their laws in a better way, that have had robust right to information systems that are working and that we're just not following. So from that perspective, I think that the idea that we've hit this milestone of 25 years without any major changes in our legislation, that's astonishing. It's good to mark that, but hopefully, hopefully this isn't going to be one of those, same time next year situations where we'll just be marking 26 and 27 and 30 and 35 years. Hopefully something will be done sooner rather than later.
Thank you very much. I don't know if that's a pitch for Bill Murray as our next premier or what it is, but the actor. Anyway, anyone else on the panel want to add any comment to that? Lots of space to do so.
Maybe I'll just make a little comment about how the technology has changed, and that brings up all kinds of new issues and concerns and ways to think about access to information. And this law was written at a time when government records were primarily paper-based. So these days we're dealing with much more electronic-based communication. Almost every department has a Twitter account, a YouTube feed. We've got social media happening all over the place. So the technology has changed. The law itself does not address those new technology issues. it's being used still and being applied as much as we can. There are the definitions are broad enough that you can kind of make it work, but it does pose some challenges in terms of what is a government record. The current law has a broad definition, but does not necessarily tell us how to deal with text messaging, for example, or what do we do when politicians or ministers are using multiple email accounts to communicate, and when are those one of those issues, when do they become public records that are then subject to the Act and can be requested through an access to information request, and when are they not? So those are some of the issues that come about because our law is quite old, and some of these new technologies just weren't contemplated when the law was written. So that's sort of on the challenge side. On the other side, there are some benefits that come from some of the accessibility in terms of digital media and records being available in digital format. Sometimes it makes them easier to be disclosed to applicants, and it makes the cost of providing the disclosure come down a little bit. We're not always photocopying, and I'm getting a little bit more into another question about fees and how much it costs to make a disclosure. But the availability of digital content does impact on how governments process access to information requests. But the law itself, because it was written before these things existed, does not, for example, allow for an applicant to require that disclosure be made in a digital format or any particular format. And so that can become challenging in terms of a government that maybe doesn't want to make a disclosure, it's only available in a certain format, but the applicant cannot themselves request that it be made in a format, or if it's a database type format, they can't require that it be made available to them in a format that they can use. So there are some nuances there that the law just is not designed because of the new technology that didn't exist when it was written.
Any other ways in which change is, all right? Okay, go ahead.
Maybe just one short anecdote to follow up on that point there. We submitted some requests, not in Nova Scotia at the federal level, and when they aren't sending you a paper version, they'll send it back on a CD-ROM, which a couple of years ago would have been great, but in my small office, none of us had laptops that could read CD-ROMs anymore, and it took us forever to find a way to read this CD we had. So I do think that the pace of changing technology, just in terms of making documents available, it should make it easier. You'd think you'd just be able to attach it to an email or something, but of course, it's not that easy.
I don't know if this is a good analogy, but maybe it's like the internet generally, which is supposed to bring everybody together and sort of promote all this interaction, but it's produced more isolation in many ways, so maybe it's a variation on that. Anybody else on this one before I move on? Okay. Next question, which is for Laura. Nova Scotia's access to information laws allow public bodies up to 30 days to respond to access to information requests. Is 30 days too long, too short, or just right, sort of like the Goldilocks and the Three Bears? Right? Why is it important that public bodies respond on time? What should happen if they don't respond to applicants in a timely fashion?
Okay, so the first thing to note about this question is this the first, when you submit a request for information, does the first deadline of when you get a response or when you get the information. But then there's also the ability of the public authority to extend that deadline. So we have to talk about both when we're talking about the speed of this. So under the current law, the public authority has to respond in 30 days, and then they may extend up to another 30 days, and if they get special permission, then it can go beyond that. So it could potentially be 60 days. That's not great. It's not the worst, I suppose. I mean, I would kind of describe it as the bare minimum of what a law should have. There are a lot of laws, again, my experience is a little bit more on the international level. If you look globally, a lot of laws do have 30 days. They tend to be the outdated laws and the older laws, when you still had to go to a library or boxes in the basement, I assume, to pick up some more documents. But now we see lots of countries that have, there's a few that have it as short as like 5 or 7 days, sometimes 10 days, 2 weeks. 30 days is really, it's a bit long. In most cases now, when information is available, electronically, it shouldn't be taking that long, and there's no reason for it to take that long. The other thing to keep in mind when we're talking about speed is that if a government or a public authority is having trouble meeting that deadline, it may reflect a broader problem of records management. And so I think when we're talking about these deadlines, we also need to be talking about broader questions of are we also encouraging public authorities to maintain good records and have things in a system where they can easily pull them out and respond to a request. So yes, I would say that's a bit long. And especially I'm concerned about the ability to extend. I think that can be quite a problem too. There's also ways of splitting hairs to find other ways to extend if you've got an authority who's not very cooperative. So for example, again, we had another request last year, again at the Canadian level, where we sent in our questions with our $5 fee and the authority sent it back and said, well, technically you need to pay us another $5 because there's 2 questions here. So not only was it a bit of a pain to send off another $5, this was all done through mail. So it took another 2 or 3 weeks before they even started tolling their 30 days. So there's all these little ways where this can add up, and that can be a problem. What are the consequences of when this takes so long? Well, let's think about the main people who use Freedom of Information requests. Journalists and lawyers are 2 of the main persons, and they're both on deadlines. If you've got a story to write, you can't wait months and months for a response, or 60 days, even if it's sticking to what the law requires. Same with if you've got pending litigation, you might not have that much time. I know when I was back in the States, I was doing some pro bono immigration work, and you're trying to get information about your client, and they might have a court deadline or an administrative deadline that they're going to get deported, and you might not get your information in time. So the stakes are actually quite high for individuals if they're not getting their information in a timely manner. And I think it disproportionately also affects more vulnerable parts of society too, who might not have the know-how to word their question in a smart way, so it gets a faster response. We can go more into that, but I'll end it there.
Thank you. Any other panelists want to add anything on the timing question and the importance of timing in terms of real right to access? Michael?
Yeah, I'll just briefly, because this does tie in as well to the digitization and the fact that this was designed at a time when we were working exclusively with papers, and it was literally people digging through mountains of files to try to find the one piece of paper that was under request. Now everything is digital, and yet the responses are taking longer. You mentioned the extensions. These can run up to years. The longest one that I saw was 80 years plus for an information request, which, to say nothing of, well, it's not that much utility to the journalist anymore, who probably won't be live anymore. But his grandkids might have a great story. But I remember, we were working previously on developing right to information legislation in Myanmar. And I remember conversations with the government over there where we were talking about, well, is it going to be a 2-week or a 30-day deadline for response? And they would say, well, the concern is, we've got all these documents from the British Raj, and they're in these warehouses, and they're very mildewy, and we can't move them all together one at a time, so we might need a little bit longer. And I just remember thinking to myself, like, wow, what is Nova Scotia's excuse compared to this? These people that are going through, like, warehouses of moldy, decaying papers to fulfill their information requests, as opposed to typing it into a computer and, well, I need 30 days to do that. I mean, I think that it's another conspicuously outdated aspect of the law.
I think it's important to add maybe some of the experience of the Information and Privacy Commissioner's Office on this question. I can't really comment on broadly the state of records management in Nova Scotia, but I will say that many of the files that we are reviewing involve boxes of paper records, even to this day. Now, maybe some of that's because some of the files that we're working on now actually were filed with our office several years ago, but not that many years ago. So there's that piece. But in terms of what happens that part of the question. What happens when a public body doesn't actually comply with the time period? Unfortunately, under our law, really nothing at all happens. It's pretty unsatisfying from the perspective of the applicant. I can say that our office has seen about 172% increase over the past 2 years in the number of requests by public bodies asking for a time extension past that 60 days. There are criteria in the Act under which our office can approve a time extension past the 60 days. I can say that our office actually approves the vast majority of them. We put them through a pretty rigorous test, but we do approve the vast majority. Unfortunately, the ones that we don't approve, it doesn't seem to make any difference. The public body simply does it anyway. They set their own timelines, and sometimes they don't even comply with the timelines that they set themselves. And I think I'll also point out our previous commissioner, Catherine Tully, one of her last review reports, it's on our website, review report 19-06, documented an extreme example of arbitrary and unjustified time taken to respond to an access to information request. And having worked on that file, it's really quite mind-boggling how the public body how long it takes the public bodies to go through the process of, first of all, searching for the records, and then once the records are found, accounting for them all, and then going through the tedious process of deciding how much of that information can be disclosed, which of the exemptions might apply, which information are we comfortable putting out the door, and which information do we want to try to fit under another exemption. So that's where the time is taken, is in the decision-making process around how to release information. That's certainly our experience with it, and that unfortunately, again, the law simply does not have a strong enough enforcement mechanism, and when public bodies don't follow the timelines that are set out, there really is no consequence for them. They just go about their business, and it gets released whenever it gets released. So this is part of the recommendations that have been made to strengthen the law, specifically for some stronger enforcement mechanism and for some consequences. And one of the recommendations is that if the public body does not follow the timeline that's set out, that in fact any fees that have been paid should simply be refunded to the applicant for their trouble of having to wait extra for the disclosure.
Any other? All right, next question, which is for Janet. The Act allow public bodies to charge fees to applicants under limited and specific circumstances. Some people see fees as a barrier to accessing information. What do you think? Should fees be allowed? And maybe you can just briefly explain what kind of fees are involved.
Sure. Okay, so fees, there are really two types of fees that are allowed under our Act. Let me start out with, if you're requesting access to your own personal information, no fees will be charged. There's no application fee and there's no processing fee. So that's one good thing about our Act, and it does make access to information when it's your own personal information more accessible. And that's really important because people who are accessing their own information, often it is for the purpose of advocating for themselves. And it often is marginalized or vulnerable parts of society that are making use of that. So I think that's one very positive part of our Act. So when you're requesting general information, so this is not your own personal information, but any other type of record held by a public body, there's a $5 application fee. Many jurisdictions across the country have done away with the $5 fee. It's not very much money, so it's intended to really deter frivolous applications, but it's only $5, so it's not intended to be a great barrier for the public. Government released this week statistics on their access to information requests, and we can see that the $5 application fee generated $13,565 for public bodies across the province last year. They didn't report the cost of processing those fees. We suspect that it probably costs more to process each of those $5 fees than it actually generated. So we're not certain that it's really worth it, and we're not certain that it really does, its intended purpose. But that's one of the fees. The processing fees are really where it becomes very serious and important. So currently, when a public body receives a request, they must do the first 2 hours of work on that request for free. So that involves searching for the requested records and then any processing. And the processing, when they say processing, that refers to the work that they do to review the record and determine if information must be withheld because it might be personal information of another person, or it may be withheld using one of the exemptions under the Act. That's where they tend to spend the bulk of the time, is on making the decisions about how to disclose records. So we have seen some overall decline in the number of amount charged. We think it's related to the ability to disclose more records in electronic format. So public bodies are, if it's being disclosed in electronic format, they're not charging the photocopying fees. So the regulations set out some benchmarks on how to charge fees, one of which is if it's going to be provided in paper format, the public body can charge up to 20 cents per page for photocopying. If there are a lot of pages, that can add up to a lot of fees. So again, moving to electronic disclosure format can eliminate some of the fees, but the real issue that we have observed here in Nova Scotia is not always about the final fees that are charged. It's really about the fee process. So when an application is received, the public body does a preliminary search. They generate an estimate of how much they think that they will charge. And they actually don't process anything until the applicant pays at least 50% of that estimated fee upfront. In 8 years, our office has seen 143% increase in complaints about fees. In investigating those complaints, we have certainly encountered at least some public bodies' fee estimates that can only be described as astronomical amounts, with very little basis or effort to work with the applicant or to put a realistic fee amount, which really leaves the possibility that public bodies use the fee estimate as a way to discourage or dissuade the applicant from continuing with the application. I want to be very clear, this is not in every case, certainly not, but as I said, our office has seen a 143% increase in 8 years in complaints about fees, and we certainly have encountered cases where the fee estimate that was put to the applicant is very, very difficult to understand, and as you work through the process, the fees are decreased significantly. So if an applicant decides not to pay the fee, that's counted as an abandoned application, so they don't go through with the application, they don't get their access to information, the application is never processed, and as I mentioned earlier, the provincial government this week released their statistics on access to information requests, and although there's a mention about abandoned requests, I found it a bit curious that there's not publication of how many of those abandoned, well, first of all, there's not a publication of how many applications were abandoned and how many of those were abandoned because the applicant couldn't pay the fee that was put to them as a fee estimate. So we don't know fully the extent of how much that is happening, but certainly from the requests for review of fee decisions that our office is seeing, we do see many cases where the fee is a barrier for the applicant, that it appears that, at least on occasion, it is being put to an applicant as a way to try to discourage or dissuade, and that sometimes applicants don't go through with their request. Sometimes applicants do go through with their request. They pay a lot of money, and they pay the money in advance, so they don't know whether they're going to there's going to be a fruitful disclosure from the request itself. itself. And so oftentimes an applicant may come back later with another request for review because what was actually disclosed was not very useful. Most of it might have been redacted, and so they paid a lot of money for disclosure that most of the information was in fact withheld. So this is, I think it's a challenging issue because, Nova Scotia is a small province. We're not awash in money, and so fees are partly a way for public bodies to try to recover some of the cost involved in processing and putting together applications, and I think that's fair enough. It's not done for free. In fact, it's much better if resources are dedicated to access to information requests, and that we don't have public servants that are trying to do this off the side of their desk. So we understand that there's a cost involved, but we also certainly at our office see when that does become a barrier for applicants, and the process of putting an estimate forward and requiring the applicant to pay up front sometimes results in the applicant in fact abandoning their request altogether.
Okay, anybody want to add anything on that? All right, let's move on then to the next question, which is for Graham. How does the attitude and culture of government at the leadership level and on the front lines affect the public's right to know?
It has a profound effect on the public's right to know, the attitude of the leadership. It doesn't matter what the law says, it will not work if the people at the top don't believe in it. And if you talk to the people at the top and say, do you believe in this stuff? They'll all say yes, because they do. But see, the challenge is, we're talking about a right to information, and that means that when freedom of information clashes with, for example, political interest, which one wins? And if it's truly a right, the right will win. That's what it means to be a right, is it's a trump card. The political class does not believe that. The political class believes that your right to information must be balanced with other considerations, including their own interest and their own judgment about what is best for the government and the people of the province. So they do not accept that it's a right. So let's just accept the fact that politicians are a big part of the problem here, but it's not just because they're evil. I was one. And they're not. A lot of them are just busy. They're busy. A lot of our politicians, you wouldn't believe how much of what happens in politics is explained by the fact that the politician just doesn't know that much about the subject, right? They're kind of scared. They're not very well informed. They're juggling 100 balls. They got to remember what's going on back in the constituency, because there's people back there that are going to decide whether to get reelected or not. So they always got one eye back in the constituency, even when they're a minister. So a lot of it has to do with stuff being dropped or fumbled or not being given a lot of attention. I'm going to leave the politicians aside, because a lot of it is that, but it's also direction from the center, from the Premier's office, who they will not release information they don't want to release, and anybody who tells you otherwise is pulling your leg. I'm going to say something controversial now, though. I don't know if I've ever said this out loud before. Before I get to that, let me say that. How many people in the room are administrators, or have been? Administrators are not the problem. The Fort Pop administrators are not, in my experience, the problem. Although they do have the normal civil service attitude of being defensive. I heard Donald Savoie saying just recently, quoting somebody saying that if the civil service had a hockey team, it would have 6 goalies on it. Yeah, that sounds about right. It's like the worst thing you can do is make a mistake. And that attitude is pervasive in the civil service. So you do anything rather than make a mistake. And so that means things like over-claiming exemptions, right? Not really applying what the O'Connor case said about a large and liberal interpretation. If you have any doubt, just exempt it, and then see see what comes out in the wash. But I think our administrators, our Fort Pop administrators, are fundamentally under-resourced, under-supported, and too quickly blamed if anything goes wrong. All right, administrators aren't the problem. Politicians clearly are part of the problem. The controversial thing I'm going to say is that, I've never said this out loud before, I think the real people that we need to focus on, where the real problem is, are deputy ministers. Because the anybody in here a deputy minister? I don't care even if you are. Deputy ministers are the people who are the chief advisor, the chief civil service advisor to the ministers, the elected officials, and the leader of the department. And we desperately need them to be the ones who implement the law the way it's written, to say to politicians, you can't do that, or you have to do it this way, or here are your choices, minister, but that over there that you want to do, that's not one of the available choices. That's what we need our deputies to do, and they're not doing it. They're not doing it. They're trying to keep one foot in the political world and one in the civil service world, and they're not good politicians. And we don't need them to be the ones trying to balance all these competing considerations. We need them to say to the political class, this is the law, and we will not break the law on your behalf. That, I think, is where, when I talk about leadership then, I'm not just talking about politicians, I'm talking about the civil service leaders as well. And if they don't believe in the law, then it doesn't matter what we write, it won't get implemented.
You heard it here first. So anybody else?
Yes, definitely. So, just to kind of pick up on that a bit, I've never worked in the civil service, but I've spent a lot of time talking to folks that are in different government departments, both on the provincial level and at the federal level. Prior to this position, I worked with the Open Government Partnership, assessing Canada's open government plans and working with people in the offices of something like 10 or 11 different ministries and a bunch of different departments. So I wouldn't think that statement about the deputy ministers would be a controversial thing. I certainly agree with it, but I would add that I don't think you get to be a deputy minister by taking a lot of risks. I think that these are career civil servants that have had a very long career, and they've advanced the way that they have advanced by being careful and conservative in their attitude towards their work. And I think that is also what is reflected in their attitude towards disclosure. Disclosure of information always carries risks. It is unpredictable. You don't know how the public's going to react. You don't know if it's a journalist, what kind of story they're writing. You don't know how it's going to be interpreted. There's all these question marks that come with releasing information. Whereas keeping it secret is safe and you know exactly what's going to happen. Particularly if you're in a context where even if an appeal is filed, you can always just push back and refuse to and even if you lose that appeal, you can just push back and refuse to disclose the information regardless. It's a very safe option, is to just, regardless of whether you're complying with the act or not, to refuse to disclose that information. So I think that is part of the incentive structure. I think that plays into the discussion of order-making power and oversight, which has come up a bit and I'm sure is going to come up again. But I will mention again, when you talk about leadership at the top, that old adage about how the fish rots from the head and all that, I think that the messages that you get from the Premier also have an impact. And when you have, as we had in this province, the Premier saying openly, oh yeah, well if I have a sensitive decision, I just don't write anything at all. I just do it over the phone because I specifically don't want to have any written documentation that can be FOIA-popped. If the Premier is saying that, what kind of message does that send down the line as to the importance of transparency, the importance of the FOIA-pop to the administration, and the attitude that they want to take towards disclosure? I think that those messages can be very powerful and can be very problematic in attempts to promote good faith implementation of the system.
Anyone else want to question is, Nova Scotia's access to information laws have been in the spotlight this past year, with the former commissioner and others calling for modernization. The government has stated that it will be reviewing FOIPA. What changes would each of you like to see and why? So this is our, having described and discussed the problem, what do we need to do about it? So with that, I'll start at this end. Maybe I'll do Laura first this time around, just to throw everything off.
Now I have to come up with something. So I guess a couple of things. I'll start by saying, so the Center for Law and Democracy, before my time, did an analysis of the law with recommendations back in 2013, I believe. So if anyone's interested, that's a more detailed analysis that gives very particular recommendations. Our website's a little hard to navigate right now. We're working on updating it, nonprofit challenges, but maybe I'll tweet about it after this event, so tweet the link to it so you guys can find it. Anyways, if anyone's interested, I can point you towards that specific analysis, which gets into the weeds. More generally, a couple main things. We've already talked about the fees and the timelines issue, and I do think those both need to be addressed. But from the perspective of the international standards, both of those are not where they should be, specifically the fees, actually. So those both, I think, need to be looked at. The exceptions regime. So the exceptions regime refers to the grounds on which a request can be refused. And there's a wide-ranging list of reasons why that can be, and some of them are very valid. I mean, there are good reasons that any government has for keeping things confidential. The current list of exceptions in the law has quite a few that are worded in less than precise language, or that, again, is just a little bit broader than it should be compared to, the international standards that my organization uses as a baseline. And the problem is when you have that vague language, it gives a lot of wiggle room for organizations to be careful and to avoid the risk of disclosing information. If you don't have to disclose it because you can find wiggle room in an exception, then you'll take advantage of that. So I think the exceptions regime needs a second look. A big one is that the commissioner only has, and I think this will, I don't think I will be the only one to say this, maybe I'm wrong, but the commissioner only has the power to offer recommendations, and the lack of enforcement power is a big one. I mean, that makes it very difficult to follow through and to ensure that when a public authority is not complying with the law, that change happens to make sure they start complying. I think an important part of that is that when the recommendations are not binding, that effectively places the burden on the person who's requesting the information to bring a lawsuit, because that's the only way to challenge it then. And if we're realistic, I mean, the average person who's making a request is probably not going to have the funds or the resources to pursue litigation. And so the reality is that anything that places that kind of burden on the applicant just isn't going to work in practice. Let's see. I think that covers the main points. I mean, again, there's a lot of little tweaks here and there. Oh, the one other thing I wanted to mention, some of the provisions about positive promotion of the right to information could be stronger. So the right to information isn't just about responding to requests you get. It's also about something called proactive disclosure, which means putting information out there before anyone requests it. It's also about making sure all of the different authorities have the proper training, then the officers have the training to know how to handle right to information requests. It's about making sure that authorities are reporting on whether they are, on the kinds of information requests they get and whether they are fulfilling or responding to those requests. Not all of that responsibility lies with the external oversight body, the commissioner. It should be on the authorities themselves. And I think by raising some of those obligations, it could create more of a culture of openness. So I do think that's important as well, not just to focus on the procedure for requesting things, but also is the law generally promoting authorities to be open.
Okay, so what do we think needs to change in the law? There are so many aspects of this, and many of the things are interrelated and intertwined. So in approaching this question, I really kind of tried to boil down my top 5. So I'm just going to kind of run through them like a top 5 list. Not like David Letterman, I don't have a top 10. So top 5, at number 5 I have clarify and update who this or these laws apply to, who is a public body. So first of all, I just want to say we actually have 3 different laws, well, two laws that deal with access to information in Nova Scotia. We have FOIPOP, which we've been talking about. This applies to provincial public bodies. And then we have the Municipal Government Act, which applies to municipal public bodies. Both of those acts have some challenges with identifying precisely which bodies are subject to those laws. And so I think that that's something that really needs to be clarified. We've certainly run into examples of where it's difficult to tell based on what's in the act. And there are schedules that have lists and they're not up to date. So a really good example of a type of organization that is clearly covered by access to information laws in other jurisdictions across this country, but are not clearly covered here in Nova Scotia, is professional regulator bodies. And that's just one example of the way the law is written. It's difficult to tell. Those bodies have resisted the law applying to them. It's extremely explicit in other jurisdictions, but it's not here in Nova Scotia, and that's something that needs to be improved. So my number 4 on my top 5 list is really to reorganize and tidy up the cumbersome 3-act conglomeration that is this regime. It's very confusing. It introduces gaps and inconsistencies, and what I mean by a 3-act conglomeration, I mean we have FOIPOP, Freedom of Information Protection and Privacy Act, that applies to the provincial public bodies. We have the Municipal Government Act that applies to municipal public bodies. And then we have the Privacy Review Officer Act, and that is what gives the commissioner the ability to review privacy issues, which are covered under both of those other 2 acts, except that it does not give the commissioner the ability to review privacy issues under the Municipal Government Act. So if you have a privacy complaint dealing with a municipal public body, there's in fact no ability to come to our office whatsoever to have an independent review. So that's getting a little bit outside of the access to information, but it is all under these 3 pieces of legislation. It's very cumbersome, and because it is this 3 pieces of legislation, I've just mentioned one of the gaps that results from that, but there are others, and there are some slight differences in the language in the 3 acts that make it difficult to operate. So that was my number 4, is tidy up that 3-act conglomeration. Number 3 on my list is duty to document. We do not have what is known as a duty to document, and it's an important requirement that exists in some of the more modern laws on access to information. It gives a mechanism where you can address the strikingly high prevalence of access to information requests that result in no records found. So when someone makes an access to information request and the response that comes back is we don't have any records, and then applicants get very frustrated because number one, it seems to them there should be records on whatever it is they're looking for, but there's no mechanism in our law to look behind other than to ask a public body to search again. But there's no mechanism to hold a public body accountable for the kind of documentation they do, the amount of documentation they do, and the ability to then retrieve documents from their records management process. So that's my number 3. Number 2 on my list is full independence for our Information and Privacy Commissioner. And when I say that, I mean that the commissioner should be an officer of the legislature. Nova Scotia is the only jurisdiction in all of Canada that has this process where the commissioner is not an officer of the legislature. It would formalize the new title of Information and Privacy Commissioner, and really where this matters the most is having full independence and being an officer of the legislature would give the Information and Privacy Commissioner more power to determine their procedures, resources, and staffing issues. And so that makes a lot of difference when you look at our most recent Information and Privacy Commissioner, who for the entire 5 years that she was in term made requests for additional staffing and additional resources in order to be able to keep up with the demand for independent review of public body decisions. She was not successful in achieving the level of staffing and resources that she required. And I find it actually quite astounding that staffing and resource decisions and those requests go first for approval to a department that is subject to the independent review of the Information and Privacy Commissioner. If that's not an actual conflict of interest or bias in this process, it certainly has the appearance of one. And so my number one on the list, and this is to echo Laura's comments, I'm sure we'll all probably mention, is an effective enforcement mechanism with the power to compel witnesses and the production of documents. Some people will talk about this as order-making power. In other jurisdictions across the country, the Information and Privacy Commissioner has the full power to make orders that are equivalent to the orders of a Supreme Court judge. That's one model that exists. There is another model. Newfoundland recently, at least in the last few years, innovated a new model which it is maybe a good model for a small jurisdiction. It doesn't require some of the infrastructure to carry off a full order-making power enforcement mechanism. So I'll just spend a minute describing that Newfoundland model because I think it's an important one for Nova Scotians to consider. And so really I call it the flipped onus model. And this really gets to the point that Laura was making about placing the onus on the applicant to go to the Supreme Court in order to obtain a court order forcing a public body to comply with the act is a very heavy burden on the public. Many do not have the resources or the wherewithal to make that happen. It often requires a lawyer. It certainly requires some resources to do. On the flipped onus model, which Newfoundland has innovated, the onus is in fact on the public body to go to the Supreme Court. So how it works is if the commissioner has made a particular recommendation and the public body decides it does not want to follow that recommendation, this happens in Nova Scotia quite regularly, and there's no consequence unless the applicant decides to go to Supreme Court. But in Newfoundland, if the public body decides not to follow the recommendation of the commissioner, it's the public body that has to go to the Supreme Court and request the permission of the court not to follow the recommendations of the commissioner. So it puts the onus on the public body to obtain that court order in order to not follow. So it means that the public body must follow those recommendations unless they themselves are prepared to go and seek that permission from the court. So in terms of looking at the needs of a small jurisdiction, it's certainly a model that, as far as we understand from our colleagues in Newfoundland, is working fairly well and has put a different context in place. And it does make the recommendations of the commissioner be taken much more seriously by public bodies. And it means that public bodies do not have the option to simply ignore the findings and recommendations of the commissioner that they choose not to follow. So that's my top 5 list. I'm going to pass it along now, and yeah, thank you.
Thanks. Oh,
I think
Yes, you have it. Yes.
Two mics being too close.
Sure.
So Michael, over to you.
yeah. So I pretty much agree with these areas of prioritization. If we're talking about reforming legal reforms to the access to information, to the Freedom of Information Protection and Privacy Act, I guess now is the time when I bust out my signed letter from Stephen McNeil back when he was first running for premier, promising that he would institute order-making power and make other changes, including do better work on timelines. I carry this around with me everywhere I go in case I see it. October 4th, 2013, a week before he was first elected premier. So, you know, I basically agree with what's been said previously. I guess I would differ a little bit on the order-making power insofar as I see like an Ontario or a BC type strong order-making power as being preferable. You mentioned the size of the jurisdiction. I personally never understood the downside of having a stronger order-making power as opposed to the Newfoundland model, but I also agree that the Newfoundland model seems to be working fairly well. Although the latest development of that is that there's now a lawsuit by the government is constitutionally asking for constitutional review of that to get permission to not share information with the Information and Privacy Commissioner that's related to solicitor-client privilege. So there's a little bit of backsliding there, but I'm not sure that that can be connected one way or the other to the model of order-making power. I do believe strongly that rather than focusing on one area of review or another area of review, rather than focusing on individual reforms, that we should be looking at root and branch review and revamping of the entire legislation. We've talked a lot about how it's been 25 years. Like, the law really needs to be restructured rather than tinkering around the edges of it. That being said, hearing that this government is undertaking a major review of the law, like, that personally makes me probably more anxious and nervous than hopeful. My experience tells me that the longer a government has been in power, the more hostile they get towards issues of transparency and access to information. And if you want to get strong reforms pushed through, the best time to do it is right after a government comes to power. Because when a government's new on the ground, all the information, all the documentation, all the scandals are basically the property of the previous administration. So if you want to get a new government in, and they immediately say, awesome, we're going to revamp transparency, we've just been elected, we're all idealistic, we're going to revamp your access to information framework, and if the next week those changes lead to some kind of scandal, it's like, gosh, those people who were in office before us had some pretty nasty policies. It's a good thing we're in charge now. And the longer a government gets into power, the more hostile they get towards this issue. It's also because access to information, we talk about journalists and civil society, it's also a very useful tool for opposition politicians who very frequently use the Access to Information Act in order to get better information on things that the government is potentially doing wrong that they can use for political ammunition, which, as you can imagine, is incredibly popular by the government to see opposition politicians using it in that way. So, if an opposition party takes power, maybe they can remember that time, and they've been speaking about access to information at the time in opposition. Maybe they'll carry some of those ideas with them, but it's not unusual for opposition parties that come into power to change their opinion of the right to information legislation for obvious reasons. And now, it usually doesn't happen as quickly as it did in this case, because it was less than 6 months into power before Stephen McNeill was saying, oh, no, the system's working well enough as is, we definitely don't need improvements to it. So you usually don't get a U-turn that quickly, but typically over time, administrations get more hostile to transparency. So the idea that now, not only after having been in power for a while, but having come to office, including having made promises specifically on improving the Freedom of Information Protection and Privacy Act, and having broken those promises and not having suffered any electoral cost for that, the idea that they're going to suddenly have a Paul on the road to Damascus moment and revamp the law, I think is not particularly likely, and if there are major changes that are made in this review, my bet would be that it makes things worse rather than better. So that's why I'm slightly nervous. But that being said, in order to not be too pessimistic, we talked about the Newfoundland reforms. The reforms that were made in Newfoundland and Labrador, which was the biggest revamping of a law that we've seen in Canada, certainly in the time that I've been active on this issue, that process started with a governmental attempt to gut the access to information legislation. And that led to a backlash, and then there was another scandal connected to that, and then there was a reshuffle within the governing power, and so they introduced a whole bunch of reforms to try to regain public trust. So, who knows? Never say never, and hope for the best.
Right, last but not least, over to you.
I had mentioned that what I think is my biggest legacy in freedom of information over 25 years is having been the legal counsel on the O'Connor case, which went to Nova Scotia's highest court. But there's very few cases very few people who can afford to go to court. I mean, the reason why that case went to court was it started when I was an employee, a paid employee of the NDP caucus office who happened to also be a lawyer. So I did it as part of my job. I didn't get any extra money, I didn't send out a bill. That was just part of my job. And the case actually ended after I'd been elected as an MLA, but then I had my MLA salary and I certainly wasn't, going to send out a bill. So, and then we did it again. I did 4 times. O'Connor is the best known one, but we went to court 4 times. Who can afford to go to court now? And nobody can afford to go to court. The other group that used to go to court once in a while at least was journalists, right? There was one of the very first FOI cases in Nova Scotia was brought by the Daily News, the gone and long lamented Daily News. But even organizations like the CBC, they don't have money to go to court anymore, and very rarely. Anyway, litigation, I think Lord said, litigation doesn't work as the last resort to enforce the law. So, if I could wave my magic wand and change 2 things, it would be, first of all, order power. None of this is going to work. None of this means anything if the government just gets to decide whether they're going to follow the recommendation or not. I didn't used to believe that. I used to believe in political consequences. If a government was willing to take a stand and take the public consequences, I thought that was enough. I don't believe that anymore. That's one of the changes in my thinking over the last 25 years. It doesn't work. It doesn't work. It doesn't work. If we're going to call this a right, then there has to be a way to enforce it. We don't have a way to enforce it. First thing, order-making power. Second thing, maybe this will be controversial too. There has to be punishment. There has to be punishment for not following the law. The reason why the law is not being followed today is there's no consequences. There are no consequences. You miss a deadline, so what? You missed a deadline. When I became Minister of Economic Development, there was a file on my desk of a FOI request that was a year overdue, a whole year overdue. There are no consequences for that. There has to be punishment. What if a minister conducts government business on private email? That's wrong. They know it's wrong. That's why they do it. And when they get caught, they said, well, it was just that one time. Liars. It's not. They're all doing it, and if any of them say they're not, they're lying to you. They're all doing it. I did it. All my colleagues did it. All the ministers now are doing it. And if they're not personally doing it, because politicians love plausible deniability, their staff are doing it on their behalf. And it's all designed to get around freedom of information. And they know it's wrong, and there's no consequences if they get caught. There has to be punishment. Fines, contempt, something where people say, okay, I'm not doing this. It's not worth it. And if we're not willing to do that, then the right is essentially meaningless.
All right, well, we've got a wealth of information to think about and respond to, and now is your opportunity to ask some questions, either about anything that has been said to any of the panelists, or just generally, or something that hasn't been said that you would like to be said on this topic. So it's now over to you to ask any questions that you want. And if I understand it, that if you want to definitely be heard, you can come up and get this mic. If you want to possibly be heard or not, you can ask the question from where you are, but make it audible so we can sort it out. So anybody any brave soul want to start off with a question? There, sir.
I just have a question for Graham. So between 2009 and 2013, why didn't the Dexter ever make order-making power and punishment?
Now, I can't, I know who that is, but I'm not going to say his name. That's a good question. So, but the only thing I can do is say, why didn't I do anything about it?
Sure.
And I'll tell you what, I can't speak for my colleagues. The Freedom of Information Law is the responsibility of the Minister of Justice. I was never the Minister of Justice. It was never my jurisdiction. It's because when you get into government, you get busy. I was the Minister of Finance for the first 3 years of the Dexter government, I had other fish to fry, right? I had things to do, and it was, I had to get on top of my department, figure out what all the issues were, figure out what we could do about it, and it just moved down my priority list. I'm going to assume that the same thing happened to my colleagues. As far as the Premier's office was concerned, I agree with Michael. It's like the longer you're in office, the less you're motivated to actually do anything that's going to help, especially your opponents, or might, you know, produce some embarrassing information. So it just, we got busy. That's what it was. That's what it was. It wasn't because I didn't believe in it anymore. It just, I was busy with other things, so were my colleagues, and it just wasn't high enough on the priority list to say, you know what, we have to do this. It's not a very exciting story. It's not because somebody said, we're not doing this, right? There was no evil person in the back room saying, no, GD way, are we giving that commissioner order-making power? It's just we had other things on our plate that were more important. That's the reason. And then we got tossed out.
Just a point, early on, it was mentioned that the public, it's hard to get the public excited about freedom of information, right to know. So if the public's not excited about it, the politicians aren't going to be excited about it. It's not going to be high on the priority list. At least that's my opinion anyway.
Yeah, and that's why I believe with Michael's fundamental point is if real meaningful change is going to be made, it's got to be done by a fresh government that just believes in their hearts that it's the right thing to do before they get all experienced and cynical and say, no way are we doing this. So that's right.
And perhaps part of a conglomerate that's not the Taxpayers Federation, journalists, or somebody else, because I'm a journalist myself, so we're collectively the antagonists, but we're not sort of the third party that needs to come in and speak up.
But I would add to that and say, or you make it a campaign issue. So, you know, there have been reforms at the federal level. They've been disappointing to a lot of folks, myself included, but there were reforms and some of them were quite important. So at the federal level, they've scrapped access fees beyond the initial $5 requesting fee. So those days of, you know, journalists and civil society folks coming back with $10 or $20 or $30,000 in requesting fees, those are gone now, right? That's important. I believe it was the same basket of change that said you can now get information in the medium of your choice. So no more like, awesome, you want these 50,000 pages of documents? First of all, we're going to charge you 50 cents a page to photocopy them all. Second of all, like, do you have a truck to come pick them up? Or would you like to pay God knows how much to have them delivered? So now you can actually get digital documents, which sounds so intuitive, but like that was a huge issue for journalists and for regular users of the system. And they're moving to a model of order-making power as well, which has been the subject of some controversy that I won't get into, but it's giving the Information Commissioner more power than she had previously. Now, how did that get done at the federal level? It was campaigned on. They promised that before the election. Now, they made other promises that they broke, right, at the federal level that they've been rightly criticized for. But it was included. They were pushed on that. It was included as part of the campaign. And when they came into office, there were changes that were made as a result of that. This right here was our attempt to insert this issue into the campaign. It was successful as far as it went. And unfortunately, you know, the delivery on that was not very strong. The provincial government has been criticized on this. I bet you if you went to the Premier right now and asked him if he regrets signing this, I think that he actually went on the record at some point and said, like, yeah, this was I really wish I hadn't signed that paper, or it was a mistake to have made that promise, which, like, I would say the mistake wasn't making the promise, the mistake was making the promise and then not following through on it. But fundamentally, like, it is possible to get political traction on this issue, because even though the public at large might not have a very strong understanding of the importance of the right to information, people understand transparency and people understand secrecy. And people know that if a government is trying to keep things secret, it's probably because they're doing things that they're not proud of. It's probably because they're doing things that if it were to become public, would cost them politically. Now, obviously that's an oversimplification. There's totally legitimate areas of secrecy and areas where the Access to Information Act should be exempted from applying to. Not saying that. But if you ask people about secrecy, about transparency in government as a general concept, I think that people can understand that. And if you combine that with the fact that journalists, who are such an important voice in the discourse and have this great megaphone for guiding the public debate, and that a lot of the time they do understand the importance of these issues, it is possible to push through these kinds of changes if the timing is right. It's not easy, but it's been done by civil society folks in a bunch of different contexts, and I wouldn't put it beyond the pale of possibility.
Any other questions? Yes.
Shall I just talk loudly? So my understanding, I'm Lisa Roberts, I'm currently an NDP MLA, and I don't actually file access to information requests, but certainly our caucus staff do, and many of them are denied or come back largely redacted, based particularly on, I guess, two of the exemptions, one being to prevent unfair advantages occurring in commercial or government transactions, and the other to safeguard the business conducted by government. And I'm just wondering, I guess I'm a little bit surprised based on my not very great knowledge of the nuts and bolts of the process, but I'm a little surprised that there wasn't a comment on your top 5 about the exemptions. And I'm wondering if the language of our exemptions is very similar to other jurisdictions, and so the problem is more in the leadership, or are there problems with the exemptions?
Maybe I'll start, and I'm sure my colleagues will jump in. I think so part of your question, how similar or dissimilar are our exemptions to other jurisdictions? They're not wildly dissimilar to other jurisdictions. And the two that you mentioned, I think it's also worth pointing out that they're actually permissive. So government may exempt based on those exemptions, or they may disclose. They can exercise some judgment there. If the exemption applies to begin with, then they can still decide to disclose. They don't have to apply those exemptions. So in terms of my top 5 list, the bigger hurdle for us is actually enforcing the law as it currently is written. We can work with the exemptions that exist if we can have it be enforced properly. And frankly, one of the bigger hurdles with these exemptions is many times public bodies believe that may means that they can apply the exemption to whatever they like, not going through an analysis of whether the exemption actually applies to the information that they're intending to apply it to, and then deciding whether they want to disclose anyway. So the bigger issue is actually with enforcing the current law. Now I know that my colleagues are going to have some, and Lori made a comment earlier about some of the vagueness of the language makes it difficult to apply, makes it much broader than in some of the other jurisdictions. There are some of the more modern laws have more precise and narrowly defined types of exemptions, and that certainly is something that could be improved in our law as well. But I think that if we don't have an enforcement mechanism, it actually doesn't matter what the exemptions say, because we can't enforce what we have now.
Yeah, I wouldn't disagree with that. And yes, I do think that the exemptions regime could use some work. And to be honest, it's the kind of thing that's a little hard to talk about at a panel because there's such a long list of exemptions, and you could go through with a red line and mark it up. But I agree. I think it's the problem with exemptions is that it's a hard thing to challenge. Like if someone sends something back and says this is the reason why, you have no way of knowing if that's valid or not. And that is why the enforcement mechanism and the possibility of a strong oversight body is so important, because otherwise, yes, the exemptions, I mean, you can kind of get interpreted however you want. So I would, if you want to look more specifically, the CLD analysis from 2013 gets a little bit more into some of the specifics on the exemptions.
can I just ask, so I'm guessing, when they list those two exceptions, do they check both of those at the same time? And do they often add one or two others just for, because my two, and this is a real tell that they're not constructively engaging with the act, is they're viewing the exceptions as this Whitman sampler of like, I'll take one of these and one of these and one of these, and let's list 10 different reasons that I won't disclose it. Throw everything at the wall, and then maybe when it gets to the information commissioner, one of them will be valid. And obviously, if none of them are valid, it doesn't matter because they don't have to disclose it anyway. And so I definitely agree with that. There was something that you said earlier that I really agree with, where if there's no order-making power, it doesn't matter what the exceptions say. Because fundamentally, if you don't have something at the back that's forcing compliance and engagement with the exceptions, and has some kind of accountability at the end of the day, then they can be interpreted in a lot of different ways. But I will note that while there isn't like wild differential between the exceptions that we have in Nova Scotia and the exceptions elsewhere, the devil is in the details. So with that being said, that yes, there needs to be proper enforcement. The devil is in the details insofar as tiny little tweaks to language can make a huge difference, even if they are being properly applied. So to take an example, just about every right to information law in the world has some kind of an exception for law enforcement information, right? But some of them will say an institution may refuse to disclose information if that request would cause harm to law enforcement activities, right? And then next to it, it can say, if there is that harm, the institution should weigh that harm against the public interest in disclosure, and if the public interest weighs in favor of disclosure, that information should still be released. So that's what you'll get in good jurisdictions, right? In other jurisdictions, it'll say, an institution may refuse information if that information is in any way related to law enforcement. So what's information that's related to law enforcement? That's a huge basket of information that necessarily includes a whole bunch of stuff whose disclosure would not cause any material harm, right? You can have lists of information that say, well, you can have an exception that lists a bunch of inclusive categories and says, we won't disclose anything related to X, Y, and Z, including X, Y, and Z, but not limited to that, which really it's just like, let your imagination run wild as to what this exception applies to. Or you can have narrow and closed categories that say, here are the limits of what is included in that exception that is strictly defined, and anything that's outside that limit, you have to disclose it, right? That's a tiny little difference in wording, but it can have a huge impact. So I will say that, like, even though the broad categories usually track in the right direction, there are problems in the way that they're structured in this legislation, which leads to those kinds of overbroad interpretations.
No, actually, not to talk too long on this question, but there is one thing I forgot to mention, which is that our RTI rating has an indicator on something called a public interest override, which is something that we consider to be a really important component of a right to information law. And what that means is that in addition to your long list of exceptions, which applies to all these narrow categories, you have a general provision that says, when considering whether any particular information should be released, you should weigh the public interest in that information against the potential harm. And I think this is really important because when you're trying to write a law on, you can't talk about everything in a law, and there's always going to be exceptions. And of course, that kind of balancing can be harder to apply in practice, but I think it does provide a really important constraint on the tendency to not disclose things that are of high public import. And the current law does not have a clear public interest override like that. And so that is one missing ingredient.
All right, any other questions?
Yes.
I have a question. Frank as a White Hawk administrator, so full disclosure. And I've worked in jurisdictions where there's order-making power, and now here in Nova Scotia where there is not. And in the last year, there have been a number of public events where the speakers, yourselves included, some of you have said that generally they believe the public body administrators to be under-resourced and under-supported. So my
if I understand your comment or your question, you are an administrator with a public body, and you don't consider yourself to be under-resourced or under-supported.
No.
Okay, and I think that is fantastic, because access to information is so important, and we certainly hear from some administrators, maybe not yourself, but from some administrators that they find it very challenging to respond to access to information requests because they don't have sufficient resources. People are doing it off the side of their desk. It's very difficult for them to manage all of the competing tasks and priorities of their other job, and sometimes access to information is an add-on that's been assigned to somebody who it was not the focus of their position. So we certainly hear that from some administrators. It's fantastic to hear that there are others out there who are not in that boat. We understand that our provincial government has gone through a process of centralizing services for access to information, and that additional positions have been added to that. So maybe that's changing, and if that's the case, then that's great. I think that means that we should be able to see individuals making access to information requests where they're getting the responses on time, where the decisions that are being made are being done well. So that bodes well for the future of access to information in Nova Scotia. Certainly where we see that the resources and support for access to information is seriously lacking is within the Office of the Information and Privacy Commissioner. We certainly are not able to make that claim, and our previous commissioner was requesting additional resources for 5 years running, and we have a backlog of requests to review public body decisions. That means that people are waiting for about almost 3 years to have the public body's decision be reviewed. So I think that perhaps things are changing. Perhaps there is more resource being applied to this area within public bodies, and if that's the case, that's terrific. But I think there's still more room to go on that one.
I wasn't clear, and maybe it doesn't matter. We're not talking about Nova Scotia, maybe you don't want to indicate.
There have been a number of public events, the Information Without Borders conference last year, this event, and one other event during Right to Know Week where that was the assertion that we're deliberately under-resourced and being supported. And I challenge it when I hear it.
Absolute right to do that. All right, come in. Great.
When I became the Fort Bob administrator of the Workers' Compensation Board, it was literally, Steele, this sounds legal, you do it, right? There was not an extra dollar, not an extra minute. It was like, in addition to everything else you are currently doing, you're now our Fort Bob administrator. Now, I don't think that was typical, but I've been around government for a long time, and when I say that administrators are under-resourced and under-supported, it's not a comment on them, because they are professionals and they want to do the right thing and they do their level best to do the right thing, but they don't have enough staff or money to do it. And what I'm thinking of specifically is the concept of an unfunded mandate. So the legislation says do this, and not only do this, but do it within these timeframes. And in order to do that right, it implies a certain level of funding. And my belief, based on what I have seen and experienced with all these different positions I've had, is that our Freedom of Information law is an underfunded mandate. It's most obvious at the Commissioner's office, where it has been saying, please. And the result of an underfunded mandate, one of the many results, is backlogs. Right? And that's one of the fundamental issues with our system today is, in theory, it works quite well, but if you have a complaint or want the review office to review it, you're looking at up to 3 years. That's not a system that's working But if there are individual units that are working well, fantastic. But I'm going to end with a question to you, and that is this something where you've noticed a change over time? Has it been getting better, or just generally has your experience been that it's been pretty good?
I can't comment on Nova Scotia because I've only been in this jurisdiction for a year. But in Ontario and BC, there wasn't this divide between admin and a review office. That there seems to be mentioned quite a lot here. I never sat in a public forum in Ontario or BC and had someone say anything to that effect. So I don't know if it's the climate here or the culture here, or it's, I don't know, I can't, because I haven't been here long enough, but I think it's important to remember that despite political will and who's in power, those requests are still going to be processed by those frontline people. And I think generally, except for those instances where they're doing it on the side of their desk, which happens I think in a smaller body than I work for presently, I think people are doing a really good job with the resources and the support that they have. And I've grown under that in this jurisdiction and others. So I say I challenge it and then I defend it because I think it's quite robust.
Maybe I can provide a little bit of clarity to the question from you, Brian. I'm Maria Oseras. I'm the Chief Information Access and Privacy Officer, and I actually lead the unit that manages POLPAP in for the provincial government. So to your question about whether things have improved, I have been in the business for quite a while, as long as back to 1999. So, and I have been through all colors of government. So, but to your question about whether things are improving or not, I believe they have. In terms of resources, I also want to point or to perhaps ask the question about, there is often this generalization that comes about the application of the POLPAP Act and the lack of resources, et cetera, et cetera. And particularly from the OIPC, we hear this concern that there is backlogs and that people do this from the side of the desk and there is no resources, et cetera, et cetera. So I just want to say for everyone here that that is a generalization that is not necessarily exclusive of the government, the provincial government. Much like in any of the statistics that come from the OIPC, that includes municipal government, includes ABCs, includes provincial government, et cetera, et cetera. So it is often comparing apples and oranges. I cannot speak for what happens in the municipalities. I cannot speak for what happens in the workers' comp. But in the departments of the provincial government, I think it's fair to say that things have improved. Maybe the outcome of the outputs are not right. I'm not going to get into that discussion. But in terms of resources and the, I guess the training and the intent of building capacity to actually apply the law and serve those customers as best as we can, it has improved, in my view, quite significantly. And the resources have been applied and provided. And we, when you compare numbers of requests with numbers of individuals that actually process POLPAP requests, and make that comparison across the country, we are pretty much aligned with those BC and the Ontarios and the Albertas of the world. Whether that is good or bad, I don't know, but it's okay.
I have vastly less experience working in the public sector than the folks on my left and right, and than either of you. But I have been in civil society and watching the system. So what I will say is, while I can't speak directly to managing these requests, requests. What I do know is that in Nova Scotia, as well as in other jurisdictions in Canada, but definitely in Nova Scotia, there is a problem with timeliness in responding to requests. That is a problem that we've seen through audits of the system, through independent research on this stuff. That's a problem. So in assessing that, the easiest answer is that there's either a lack of resources or a lack of prioritization or something. Something is creating these backlogs. Something is creating delays in responding to requests. If you're saying that your experience has been that you have plenty of resources, that's great. But again, when you look at audits of the system, it tells a different story. So I do think that there's at least a reason to think that structurally there are challenges there.
So what would in your view, what would it be an acceptable compliance rate?
What?
Because we just issued the annual report, and there is an 84 compliance rate in responding to within the timelines of the act. So what is it, in your opinion, reasonable?
So in India,
compliance rate?
virtually 100% of requests are handled within 30 days.
Come on.
Again, we're talking about an Indian system. Can we not match them in terms of administrative
Who is it?
efficiency?
Sorry, who was it?
India.
Oh.
So, I've worked more on the international side than on the Canadian side. But in India, the law is 30 days with no exceptions, and that's complied with virtually 100% of the time. In Indonesia, it's a 2-week response time, extendable by a maximum of 2 weeks. So it's 10 business days, 20 business days maximum. And compliance isn't as strong on the Indonesian regime as it is on the Indian side. But regardless, we've seen short timelines work in other jurisdictions. So I don't think it's unreasonable to think that 100% of requests could be dealt with in 30 days, because there's lots of places around the world that do that.
I'm conscious of the fact that I think it is now 7 o'clock, and people have come out probably with that in mind as the end time. Perhaps if over coffee or so on you want to do any of that further, and the participants are willing to do that, by all means. So I just want to bring this to a close by thanking our excellent panelists and the audience as well for showing up with great questions and great information, and thank you all very much. Happy access to information.